Good morning to our friends on the West Coast, and good afternoon to everyone else. This is Franklin Cruz, Director of Training and Leadership Development here at the Coalition for Juvenile Justice. And on behalf of the Coalition, welcome everyone to today's webinar, Reforming Juvenile Justice, the Developmental Approach. During this webinar, we will be discussing the recently released report from the National Research Council at the National Academies by the same name, which provides a comprehensive review of the current state of knowledge about juvenile justice and makes compelling and evidence-based recommendations for the field. Our work today will be to draw some connections between the content of that report and the work done by our members, that's SAGs, JJ specialists, DMC coordinators, compliance monitors, JBIC coordinators, and other state-level staff to promote better outcomes in juvenile justice. We are honored to be joined by three panelists. First, Betty Chemers, who is actually the study director for the report, Reforming Juvenile Justice. Betty is a senior project officer at the National Research Council. Previously, Betty held numerous positions at the United States Department of Justice, including director of the Evaluation Division of the National Institute of Justice and deputy administrator for discretionary programs at the Office of Juvenile Justice and Delinquency Prevention, OJJDP. There, she oversaw its research, demonstration, and training and technical assistance activities. Her non-federal service includes directing the Planning and Policy Analysis Division of the Maryland Department of Public Safety and Correctional Services, and consulting on strategic planning, finance, and management issues with nonprofit organizations. Betty has an MA in History from Boston University and a BA in Education Psychology from the University of Maryland. We are also joined today by Richard Bonnie, who is the Vice Chair of the Committee on Assessing Juvenile Justice as part of this report. Richard is the Harrison Foundation Professor of Medicine and Law, Professor of Psychiatry and Neurobehavioral Sciences, Professor of Public Policy, and Director of the Institute of Law, Psychiatry, and Public Policy at the University of Virginia. He was elected to the Institute of Medicine, or the IOM, in 1991. Richard teaches and writes about criminal law, bioethics, and public policies relating to mental health, substance abuse, aging, and public health. He was the Associate Director of the National Commission on Marijuana and Drug Abuse, Secretary of the First National Advisory Council on Drug Abuse, and Chief Advisor for the American Bar Association's Criminal Justice Mental Health Standards Project. He currently chairs a Commission on Mental Health Law Reform at the request of the Chief Justice of Virginia. He's also served on the MacArthur Foundation's Research Network on Mental Health and the Law. Richard has received the Yarmolinsky Medal in 2002 for his contributions to the IOM and the National Academies. And in 2007, Richard received the University of Virginia's highest honor, the Thomas Jefferson Award. Richard has a BA from Johns Hopkins University and an LLB from the University of Virginia School of Law. We are also joined, of course, by Marie Williams, who is the Deputy Executive Director here at the Coalition for Juvenile Justice. Known to many of you, Marie will be moderating a discussion at the later half of the session today. Just to briefly go over what our objectives are, we will be providing a brief overview, or really Richard and Betty will be providing a brief overview of the report, Reforming Juvenile Justice, talking about who participated in the study, the methodology of the study, and of course the major findings and recommendations. We will be particularly focusing on how the report and its recommendations and findings can be used by SAGs and state-level staff to promote your efforts to effect system change in your states. And I know that we also have a number of allies on the call today from organizations that are very much involved in juvenile justice reform. We also hope that today's discussion and presentation provide you with some ideas for how to use the report in advancing your own work and, of course, in advancing your partnership with SAGs and state-level staff. So we will get to these objectives using a number of strategies. First of all, again, Betty and Richard will present the major findings and recommendations. We will then have a discussion that's moderated by Marie, and Marie will chat with Richard and Betty about some of their thoughts in light of the report about how it is that SAGs might be able to use the findings in the report and recommendations in the report, and I think you'll see that there is a lot of room there for SAGs to use their unique positions to advance their agendas in their states. And of course, we will open up to questions and answers from those of you participating today. We will be taking questions both by chat, and we will also be opening up the lines as you indicate your interest in asking a question throughout at various points throughout the presentation today. To get us started, before I turn it over to Betty, just some background. This report is, again, the product of the National Research Council of the National Academies and was conducted since 2010 with funding from OJJDP, the Office of Juvenile Justice and Delinquency Prevention. The report has been available to the public since this fall, since November, and will be formally published in hard copy this coming spring. At the end of the session today, we will share a link with you to download the full report or to order a hard copy. You should also know that the report itself is a great read, but it is a very long report. So for your benefit, there's actually a great 10-page summary that precedes the report, highlighting some of the big ideas, some of the major findings and recommendations. And of course, throughout the report, I would encourage you to take a look at some of the exhibits that are in there and tables, which provide some great summary material as well. Betty, with Richard and Marie, will also, of course, point out sections of interest as they're presenting and talking today. So with that, I will turn it over to Betty, who will tell us a little bit about the folks behind the research.
Let me explain that our studies are done in a somewhat different manner than other sort of nonprofit research groups. They are conducted by committees. There are volunteers. Our particular committee consisted of 15 people. Cross-section, there were academics. There were 2 physicians, actually pediatricians, on the committee. We had practitioners, Director of State Children's Services from New York, a Director of State Juvenile Corrections from Texas, and a juvenile court judge from Louisiana. 2 of our members had law, public policy expertise, and there was a neuroscientist. Robert Johnson, Dean of the New Jersey Medical School, chaired the committee, and the vice chair was Richard Bonnie, who's here today. The committee had a very specific charge, and that was to assess the implications of advances in the behavioral and neuroscience research for the field of juvenile justice, and to really identify what the implications of that knowledge was for juvenile justice reform. A similar review had been done in 2001, and this was it was thought that there was needed to be an updating of that review, and as I mentioned, OJJDP funded us to do this. There were really 3 issues that we were addressing. First of all, we wanted to identify the relevant findings in childhood and adolescent development that had implications for juvenile justice. We really wanted to place these findings in some kind of context, and so we wanted to know really what was happening at the state and local level. And as importantly, what was the evidence regarding how effective these reforms were. We also were asked by OJJDP to look at its own operations and its capacity to really continue to promote and support reform efforts. The methodology that we engaged in consisted of reviewing the behavioral and neuroscience research. We also reviewed public information regarding what OJJDP was doing, what the foundations were doing, and really what was happening in your own states. We had 3 open meetings. We had about 40 to 50 people come in and talk to us about their to share information about the research, to express their views about OJJDP and really what was happening, and to offer advice and guidance to us. We also reviewed extensively the records for OJJDP and talked to many, many staff. In addition, we commissioned a separate paper on the Missouri model. Since there had been so much interest in Missouri, we really wanted to have an idea as to really what was happening there. Our report is a lengthy report. It's I'm a little embarrassed to admit it's almost about 480 pages. I will say that we have a 10-page summary that's in the front of the report. We have also produced a 6-page brief, and I will let you know how to obtain those documents. We had numerous conclusions, but for purposes of today's discussion, I'd like to go over the 4 that are the most relevant. The first conclusion is that the committee, based on our findings, noted that there were important differences between adults and adolescents, and these differences have a direct bearing on the design of and operation of the juvenile justice system. These differences are well established. They're grounded in the science. We did note that some of the science is in kind of the early stages, and there's some limitations, but it's sufficiently well developed that it can provide a sound basis for policy. Our second conclusion basically reflects that judgment that this knowledge really can provide a framework for juvenile justice policy and practice that can simultaneously hold young offenders accountable, treat them fairly, and prevent reoffending as complementary objectives. And 2 of the key words in this are simultaneously and complementary. The framework that we developed in our report is really built around these 3 goals, and we feel very strongly that these goals are compatible when viewed through what we're calling a developmental lens. The third conclusion talked really about the context, and here we note the substantial progress that's been made to embrace and implement developmentally appropriate policies and practices. Unfortunately, the committee notes that in some cases the pace of reform has been sluggish in some states, and the committee voiced concern about the fact that many of these reforms had not been well evaluated. And also as part of this conclusion, I might note that we also noted sort of the lack of data that really would help evaluate these programs. The fourth conclusion really related to OJJDP, and basically we concluded that OJJDP is the appropriate agency to provide the critical support that state and tribes and local jurisdictions need to implement a developmentally appropriate juvenile justice system. We note that it has the congressional mandate to do so, and it also enjoys the support of the field. I want to turn now to these 3 goals that we mentioned in one of the very opening slides. It seemed to us that, and the 3 goals being accountability and fairness and preventing reoffending, it seemed to us that, as I mentioned earlier, when viewed from a developmental perspective, these 3 goals really are compatible. And in the report, we lay out policies and practices that are designed to achieve these goals. And our view that these 3 goals and the policies and practices associated with them really need to be examined from the standpoint of their impact on the developmental processes and whether they impede or facilitate healthy development. What I'd like to do now is go into specifically the findings on these 3 goals. And for these slides, I drew from a box in the report entitled Guiding Principles for Juvenile Justice Reform. And here we really attempted to give a more concrete idea as to what we meant by developmentally appropriate policies and practices. And I meant to say when I was starting that Richard, who is my companion in this sitting next to me, please feel free to add any key points that you think will be useful. So the first goal we want to deal with really is accountability, and here we're really talking about a different kind of accountability, and this is an important insight that we really make in our report. That is that for youth to be held accountable for wrongdoing and accepting responsibility really has to be perceived as fair, and if it's perceived as fair, it will promote healthy moral development and legal socialization. That accountability can really serve a very, very valuable purpose here if it's handled right. And conversely, if you're held accountable and you're punished in a process that's perceived as unfair, then this can reinforce an adolescent's sense of disaffection and his antisocial behavior. And some of the ways that we talk about how this accountability might be carried out is to, and the slide has way, way too much writing on it, but the kinds of things we're talking about here are the importance of really communicating to the youth what society expects of them, and clearly one of the things is expects them to take responsibility for their actions. We really want to encourage our youth to accept responsibility consistent with protecting legal rights. We want to facilitate the involvement of the family members. And it's not just their involvement, it's also sort of their perceptions of the process and what's happening here. We state very clearly that confinement should be used sparingly and only to prevent serious offending. Above all, we want to avoid the collateral consequences of adjudication, records that follow kids, that makes it difficult for them to get jobs, to vote, to really become a fully participating member of society. The second goal that we are talking about is really preventing reoffending. And obviously, this is one of the goals probably if someone had to indicate what was the most important goal, although we do find these all equally important. I suspect that preventing reoffending would be the first one that would come to mind. And here we reiterate the fact that punitive policies that are really just predominantly punitive really do not work toward transforming a youth, helping a youth become really a pro-social member of society, and it does not reduce recidivism. And as I make these statements, I want to emphasize the fact that our statements are based on the science. And for each statement that we made like this, we had to show where in the science was there evidence for this. We found no convincing evidence that confining juveniles beyond just a minimum amount of time required to provide intense services were you going to reduce subsequent offending. And then we did, as many of you have read, reviewed the literature on the cost effectiveness. Basically, at this point, there's been enough out there that talks about the fact that heavy reliance on containment and control is just costly and ineffective. And we cite really a finding that, you know, certain interventions can achieve a 40% reduction in offending for certain offenses, and one can actually save $10 for every dollar spent. Also under preventing reoffending, we talk about in these principles, we talk about the importance of the use of structured risk and need assessments. This clearly is kind of the hallmark of a developmentally appropriate system. And the use of these really can lead to unnecessary detention of youth. Finally, we talk about, as a principle, encouraging again here the emphasis on the adolescent family as much as possible. We talk about eliminating interventions that have not been shown to be effective, and we also talk about the importance of keeping accurate data. We also make the point that these programs, and this is an incredibly, I think, useful this is chapter 6 in our report. It brings together so much research, but we do talk about the importance of maintaining fidelity and adhering to program guidelines if one hopes to achieve the kinds of cost savings and effectiveness. And then the final and third goal, the fairness issue, and we're going to actually probably talk about this a little bit more. We really feel that the lack of procedural fairness, that many systems are characterized by a lack of procedural fairness, and we note the importance of fairness, the importance of perceptual fairness to kids. And really, without it, the hopes that you are going to kind of have them have an appreciation for the law and to have some degree of what we call legal socialization, you're really going to be hard-pressed without adolescents perceiving and really participating in a fair process. And along these lines, we really do expend some time talking about disproportionate minority contact throughout the juvenile justice system and how it does play a role in contributing to perceptions on unfairness. What are the principles and policies that should be followed in terms of fairness? Well, certainly ensuring that youth are well represented and at every stage of the process by a trained counsel. In ensuring that youth are adjudicated who really are competent to understand what's going on and the fact that they've had everything explained to them. And then really having the youth participate to the greatest degree possible in all of the proceedings. Again, we turn to DMC. We feel it's vitally important to intensify efforts to reduce racial ethnic disparities. Again, that they perceive they've been treated fairly. And then we suggest that if possible, courts work to try and develop and implement evidence-based measures for fairness. And these would be based on legal criteria. For example, do they have defense counsel with different processes or questions being asked, or are the attorneys well trained? But also trying to get a handle on how is the youth and the family and other participants perceiving how they have been treated. So our findings, our conclusions really resulted in 4 recommendations. I'm going to mention them briefly. So I'm going to sort of give an abbreviated version of the recommendations. The first one really had to do with the role of state and tribal governments. Here the committee recommended that there should be established within these units of government a bipartisan, multi-stakeholder task force or commission charged with designing and overseeing a long-term process of juvenile justice reform. We're going to turn back to that because we do suggest specific ways, specific activities that might be undertaken by this commission. And I will say that this recommendation really reflects the fiscal realities regarding OJJDP and the role of federal government and the committee's recognition that change will really need to come from states, local communities and tribal governments. Our second recommendation deals with the role of OJJDP. If you recall, we were asked to examine their capability for leading reforms. And we said here that the role of OJJDP in supporting juvenile justice improvement should be strengthened through reauthorization, appropriations, and funding flexibility. We particularly talked about strengthening the core protections, and our recommendations in part really reflected recommendations of the Coalition for Juvenile Justice, having to do with how these might be strengthened. We recommended that OJJDP really prioritize its research and training and technical assistance to really focus on developmentally appropriate policies and practices. And as part of this, we also recommended that the jurisdictions participating in DMC be expanded. Our third recommendation really had to do with the role of research, and we recommended that research by federal research agencies such as the National Science Foundation, the Centers for Disease Control, and National Institutes of Health should be undertaken to advance the science of adolescent development. We are interested, we feel it's very important that this research really continue to try and expand our understanding of the ways of developmental processes influence delinquency and juvenile justice processes. And finally, the fourth recommendation really had to do with OJJDP, but also other federal agencies that are involved in statistical work. And this recommendation calls for a data improvement program on juvenile crime and juvenile justice processing to be conducted. There's a great need for more insight into state, local, and tribal variations in terms of crime and in terms of the way youth are processed. There's a need for data on age, gender, particularly on race and ethnicity of offenders. And this information basically will help communities as they sort of try and monitor really what happens to youth in their jurisdictions. Well, I got through that pretty quickly, I think, and I'm, of course, happy to answer any questions. At this point, I think, though, it's really up to you whether you want to open up for questions, but we're going to turn back to recommendation number 1, I think.
Yes. So before we move to the discussion with Marie in just a moment, we did get some questions from the audience that I hope you might be able to address. One of the questions was, how did you find restorative justice fit into the landscape of reform in your study?
Richard, how about I'm going to give you that question since you were responsible for sort of talking about it.
Yes. To go back to the portion of the report that Betty reviewed in relation to accountability, we were very interested in exploring various tools and mechanisms of accountability that fit the developmental approach that we were relying on in the report. And, you know, in a kind of a shorthand phrase, you know, trying to find accountability without criminalization and the various incidents of criminalization. And in the course of doing that, we actually did look at the literature on a number of innovations that have been used, one of which is restorative justice programs. I think in general, we believe in principle that restorative justice programs are compatible with the approach that we are talking about here. We were somewhat constrained, though, in what we could say because we don't yet have a robust literature of evaluation with regard to those programs, and as you probably are aware, there's a lot of variation in how such approaches are actually implemented across the country, even within the same jurisdiction. But the general point is we think it fits in principle very, very well, and hope that the literature will continue to develop to support it.
We also have a question from Gordon Keith. Gordon, I'm going to unmute your phone just because I think it's probably better if you articulate your question.
Well, in a lot of areas, and it depends whether it's rural or urban, in the more rural areas, when the court comes together, be it defense attorneys, prosecutors, and the judge, there's conversations about what is best for the kids. Then in other areas, what you have is you have defense attorneys that their sole point is to get the kid off whether the child is guilty or not. And when we're looking at fairness and recidivism, my question revolved around the kids that are released when they know they did an offense. Is there any conversation about an offense, is there any conversation about how to deal with kids that we know have committed these crimes and trying to get them through the process in a fair way without just getting them off? Does that make sense?
Yes.
Yes. No, you obviously put your finger on a very important issue. Before commenting on the specific problem that you've raised, let me emphasize that even in more general terms, there are wide variations in the roles that attorneys take toward the representation of juveniles, as you pointed out from the beginning. We think that infusing a developmental perspective into the training of attorneys, as well as the other participants in the process, has got to be an ongoing effort. And acquainting people with the the nature of adolescence and some of the features of it is important, generally speaking. And also trying to find the right line here between promoting acceptance of responsibility and protecting the young person's legal rights, is as you pointed out, I mean, there's an inherent conflict there. But at the same time, we also think that when the young person, for whatever the reason and notwithstanding whatever advice may have been given as to what's in that youth's best legal interests, ultimately, under our standards of representation, in the process, the youth ultimately is going to be the decision maker. And so what has to happen at that point is that you have to pick up the perceptions of fairness, angle on it, and understand that at some point these aren't going to be perfectly aligned in every single case, but in the long run, having a process in which the youth feels that his or her interests are being represented is also a valuable factor. But the bottom line answer to your question is we recognize the conflict, but there is not a perfect answer to the problem that you posed.
Okay. Thank you.
We have another question from the audience asking about whether youth were consulted as part of the report, or youth perspectives consulted as part of the report.
We did have a young man by the name of Dwayne Betts, who was sentenced as an adult at the age of 15, come in and talk to us. He's written a very, we thought, a interesting and very well done, actually, book about his experiences. But we did not consult with many youth. But it was interesting in terms of his perceptions, and he writes the book from the standpoint of what happened from the minute, just the total. A lot of the things that he experienced really were, when we looked at what the science was saying, was really just, it was a classic case with him.
And so we have another question, also texted in, asking about the definition of recidivism that was used in the report, if at all.
we note in the report that recidivism is a moving target. Although there has been an agreed upon definition of recidivism, I think that was put together by the Council of Juvenile Correctional Administrators, and people seem to be signing on to it. What we did is we reviewed in the review of the literature for Chapter 6 on preventing reoffending. Primarily, we were relying on meta-analyses that had been done and reviews of research, and it was when there was an indication that we put it in what that was. But we don't make any. We were basically relying on the meta-analyses.
Great. So we're going to just take a moment here and transition to our discussion with Marie Williams. So your screens will be paused for a moment while we make that adjustment.